Good afternoon. May I welcome everyone to the 23rd meeting in 2020 of the Delegated Powers and Law Reform Committee. We have apologies today from three of our members, Gordon Lyndhurst, Mary Fee and Gil Patterson, and we welcome Brian Whittle and Tom Arthur in their place. We also have Graham Simpson joining us today, and he will speak later. The first item of business is to propose that the committee takes items 6, 7, 8 and 9 in private, as these involve consideration of future reports. These will be published when agreed. Does the committee agree to take items 6, 7, 8 and 9 in private?
Agreed.
Great, thank you. Under agenda item 2, we are considering instruments subject to the made affirmative procedure. These instruments are in force already, and the Parliament has 28 days to consider whether to approve the instrument. If the Parliament does not approve the instrument within 28 days, it will cease to have effect. As I mentioned before, we have Graham Simpson here today with us to share his views on one of the instruments under this agenda item, the Health Protection Coronavirus Restrictions Scotland Amendment No. 7 Regulations 2020, SSI 2020-210. Graham, would you like to speak?
Yeah. Thanks very much, convener. It's good to be back at the committee, which I used to convene, so I feel your pain having to read out the notes. Yeah, as you rightly say, I just want to have a brief word about the Health Protection Coronavirus Restrictions Scotland Amendment No. 7 regulations. Now, in particular, the part of those regulations that deals with the requirement to wear a face covering in a shop. Now, it's not for this committee, as you well know, to decide whether that's right or wrong, but it is for this committee to decide whether the procedure that the government used was the correct one or not. And also, I think it's open to you to make comment whether the regulations were drafted tightly enough. So on those two issues, if I can just make some comment. You'll have seen an email that I sent to yourself, and which I hope has been shared with the committee. It's a matter of public record. When I looked at these regulations, I felt that there were, shall we say, holes in them, in that it potentially left a two-tier situation where certain premises were exempt from the requirement to wear a face covering, and certain premises were not. So the premises that were exempt were banks, building societies, anywhere that operated a currency exchange office, or anywhere that you could transmit money. Now, as I said earlier, it's not for you to decide whether that's right or wrong, but that, to me, raised the question of, well, if you had a currency exchange office, but operated by a post office, say, now often they are in shops. So if you were exempt from wearing a face covering at a post office, but you had to go into a shop to do it, that didn't make sense. To me, that didn't make sense. Similarly, if you were to wish to transmit money in some way, you could go to any one of the thousands of usually small shops in Scotland that operate pay point facilities. So I think you ended up with this, as I say, two-tier situation. Now, the committee is only dealing with this regulation, but that's been superseded by another one which was issued last week, and that is the Health Protection Coronavirus Restrictions Scotland Amendment No. 10 Regulations 2020. Now, you're not considering that today, but however, this appears to be Mr. Russell correcting the things that I raised. Yes, the Cabinet Secretary, Mr. Russell, correcting the issues that I raised in my email to you and in an email to him as well. So it seems to me that if the regulation had been drawn up properly, then we wouldn't have to have this amending regulation. And, you know, if Parliament had been able to scrutinise those regulations in the first place, we may not be in the position that we are now in. The second point is that by introducing a mandatory requirement to wear face coverings in shops and other places, it doesn't matter, again, it doesn't matter what the committee thinks of that, but that is a far-reaching piece of legislation. It seems to me that that should not be just pushed through without prior scrutiny. So I would invite the committee to make comment on that. Thank you.
Thank you, Mr Simpson. Would any of the members like to speak? Stuart?
No. Mr Simpson, thank you very much for bringing this matter to the attention of the committee. I think we will probably all agree that the COVID pandemic is something that none of us and no government across the world has ever dealt with before, and clearly the actions of the Scottish Government bringing forward the regulations in an urgent fashion have been important to do that, to try to help and deal with a situation that is ever evolving. Mr Simpson and committee members will be aware as well that the legislation that was passed in the Parliament allowed for that type of process to take place. So I think certainly from a procedural point of view and a legal point of view, it does appear that what the Scottish Government have undertaken has been correct. There has been nothing untoward happened there at all. From the technical point of view that you raise in terms of inside of shops, it's a valid point to raise, and once again I do thank you for raising that with the committee, but probably would be better for the COVID committee to consider this as compared to this particular committee, would be my thoughts.
Thank you. Mr Whittle?
Thank you, Convener. I think Mr Simpson raises a really interesting point for me around, I think, as it's been highlighted there, that the government have acted within with the competence of the legal structure. But have they acted with the consent of Parliament? I think that's the concern for me, is that there is a lack of scrutiny, especially around wearing of face masks in shops, and there are a lot of anomalies within that. And I think that, you know, I'm in the Health and Sport Committee as well, and there's a lot of different expert advice around whether it's the right thing to do and the wrong thing to do, and I don't think that's for us to investigate. I happen to think it's the right thing to do, but I think it was done, quite frankly, in the wrong way. And I think it raises the point for me that throughout this, there's a concern around parliamentary scrutiny, and I think in this particular instance, I think that we've missed the opportunity to bring forward legislation that could have been much tighter than it currently is. I mean, I heard the other day, if you go into a coffee shop, if you're sitting down within the coffee shop, you're in the queue and you sit down within the coffee shop, you don't need to wear a face mask. But if you order the same coffee in the queue and you're going to take a carry out, you have to put a face mask on in the same queue. So there are anomalies here, I think, that could have been, had it been properly scrutinised in Parliament, that we could have been much more effective. However, you know, as I said, as has been said by Mr McMillan, I think the COVID committee is the right committee to have a look at that in its entirety. But I do think we should note that. But, you know, for this committee, the government has acted within rules and regulations and the legal framework in which has been set out by the Parliament.
Thank you. Mr Arthur?
Thank you, Convener. I'll just echo the comments of colleagues in thanking Mr Simpson for bringing this to the attention of the committee. I appreciate it may have been a slightly circuitous route, but Parliament to some extent has fulfilled its function in scrutinising that legislation, as it seems from Mr Simpson's comments that his letter to the Cabinet Secretary has precipitated a revised set of regulations. All I would note is I think it's clearly recognised that when we get to the other side of COVID, which clearly may not be for some time yet, there will need to be a period of reflection and scrutinising the actions of all public bodies, but including how this Parliament has functioned and including how government has functioned. I recall at the outset of this crisis being receiving correspondence from constituents who were asking why we were waiting for Westminster to pass legislation rather than introduce their own bill immediately. Some feeling that that was we were being tardy, while others were asking why it could not have all been done at Westminster. So I think there will be a process of review and reflection when we get to the other side, as there will be for all public bodies, but particularly when we reflect upon how we have done our jobs as parliamentarians in scrutinising the legislation brought through by government. And I think this is an important point that Mr Simpson is noted, and I thank him for it.
Thank you. Would you like to make any brief final comment?
Well, I'll just thank the committee members for their considered comments. I'd expect nothing less from these committee members. I would agree with the point made by all of them, I think, that the government has acted within the rules. Parliament gave it the power to do what it's done. I'm not disputing that. I'm merely saying that I would invite the committee to maybe make comment on whether the government should have used that procedure, as the committee has done in other regulations to do with COVID. And I'm thinking particularly around planning. I know that the committee has made comment on that before. But I'm happy to leave my comments at that and thank the committee for its time.
Okay, well, thank you for that, Mr Simpson, and for your comments and giving us some advance notice of the matter you were raising. I think in summary, we agree that the government followed the rules and the powers that it had been given, that there perhaps has been some drafting that could have been tighter in this, but that they did follow the procedures, and on that basis, I would suggest that what we would do when we report to the COVID committee is to mention, obviously, that you've been here and put in that both your comments about the drafting itself and also your views on the use of the made affirmative process. Does everybody agree with that? Agreed. Okay, thank you. Now, to move on, in relation to this instrument, no points have been raised under any of the committee's technical reporting grounds. Are you, as a committee, content with the instrument from a technical scrutiny standpoint? Okay, thank you. I now turn to the Social Care Staff Support Fund Coronavirus Scotland Regulations 2020 SSI 2020-188. This instrument provides for the establishment, maintenance and administration of the Social Care Staff Support Fund. The fund has been created in order to ensure that relevant social care workers do not experience financial hardship due to being ill with coronavirus or because they are self-isolating, in line with guidance. Regulation 4 sets out that in order to make a claim on the fund, a relevant social care worker must provide evidence to the Scottish Ministers or to such person appointed by the Scottish Ministers in accordance with Regulation 2.3. This should be a reference to Regulation 2.4 rather than Regulation 2.3. The Scottish Government proposes to deal with this error by way of a correction slip. Does the committee agree to report this instrument under the general reporting ground? Thank you. Does the committee wish to note the Scottish Government's commitment to address this correction by slip? Thank you. No points have been raised on SSIs 2020 190, 199, 201, 209, 210, 211, 215, 221, 224, 229, 232, 233 and 234. Is the committee content with these instruments? Content. Thank you. Under Agenda Item 3, we are considering instruments subject to affirmative procedure. No points have been raised on the following draft instruments: the Representation of the People Electoral Registers Publication Date Coronavirus Scotland Regulations, the Abertay University and Robert Gordon University Change of Names Miscellaneous Amendments Scotland Order 2020, the Advice and Assistance by Way of Representation Scotland Amendment Regulations 2020, the Greenhouse Gas Emissions Trading Scheme Order 2020. Do you have a... Oh, just a question, sorry. Is the committee content with these instruments? Content.
Just one point, just for the interest of clarity, I did study at Abertay, so just to make everyone aware.
Okay, thank you. Under agenda item 4, we are considering instruments subject to negative procedure. Personal Independence Payment Transitional Provisions Amendment Scotland Regulations 2020, SSI 2020-218. This instrument makes provision in Scotland for changes to the age at which individuals in receipt of disability living allowance are invited to claim for personal independence payment. Extending disability living allowance awards to persons aged up to 18 years and 6 months in certain circumstances. The instrument was laid before the Parliament on 17 July 2020 and will come into force on 1 September 2020. This does not respect the requirement that at least 28 days should elapse between the laying of an instrument which is subject to the negative procedure and the coming into force of the instrument. The committee is therefore required under standing orders to draw the instrument to the attention of the Parliament under reporting ground J for failing to comply with the requirements of section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010. Does the committee therefore wish to draw this instrument to the attention of the Parliament under reporting ground J? Thank you. The committee also considers the reasons for the breach of the 28-day rule, which in this case are set out in a letter to the presiding officer dated 17 July 2020. The letter explains that the regulations have taken time to be finalised due to an intensive exercise to determine the impact of COVID-19 on the Scottish Government's plans for the further devolution of social security powers relating to arranged disability benefits. Both the Scottish Government and the Department for Work and Pensions needed time to consider whether the changes proposed in these regulations were deliverable in the current challenging environment. Is the committee content with the reasons given for the failure to comply with section 28.2? Thank you. No points have been raised on SSIs 2020-183, 213 and 230. There have been also no points raised on SSIs 2020-776 or 777. Is the committee content with these instruments? Thank you. Under agenda item 5, we are considering instruments subject to no procedure. No points have been raised on SSIs 2020-189, 198, 200 and 208. Is the committee content with these instruments? Okay, thank you. I now move the meeting into private.